Hi, my name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to briefly discuss the U.S. Supreme Court's 7-9 decision to continue to enjoin the Trump administration from removing a group of detainees located in the federal Northern District of Texas and presently held in the custody of the Department of Homeland Security. For reference, this is in the AARP versus Trump matter. To recap, in the early morning hours of Saturday, April 19th, 2025, the U.S. Supreme Court, in a 7-9 decision, issued an injunction against the detainees' removal. The Supreme Court's swift action in entering its initial injunction occurred after the government had the detainees loaded onto buses and heading to an airport to be removed to the infamous CCOT prison in El Salvador, while the group had pending litigation matters challenging their deprivation of Fifth Amendment procedural due process and challenging the legality of the government's use of the 1798 Alien Enemies Act, 50 United States Code Chapter 3, for their removal from the United States. This is because the detainees refute their affiliation with the infamous Tren de Aragua gang. Check out episode 5 for more information regarding President Trump's issuance of Proclamation number 10903, titled Invocation of the Alien Enemies Act regarding the invasion of the United States by Tren de Aragua. To recap, the statute is only intended for use in times of war or times of invasion by foreign governments, not to short-circuit the courts from deportations covered under appropriate federal laws. The Fifth Amendment of the U.S. Constitution provides in part, no person shall be deprived of life, liberty, or property without due process of law. The courts, through their exercise of judicial review, have determined that this means that people, specifically in immigration deportation matters, shall be given adequate advance prior notice so they may retain counsel and file any legal challenges where they have an opportunity to be heard before the government removes them from the United States. The process is meant to prevent accidental or intentionally illegal deportations from occurring. The U.S. Supreme Court found in its May 16, 2025, 7-2 extension of its prior injunction in this matter, preventing the detainees from being removed from the U.S., pursuant to the Alien Enemies Act, found that the detainees alleged that they were served notices of removal pursuant to the AEA less than a day before the government intended to load them on flights to remove them from the United States. This clearly would have been a violation of their Fifth Amendment rights. The Supreme Court, in its May 16, 2025 ruling, stated, quote, "Had the detainees been removed from the United States to the custody of a foreign sovereign on April 19th, the government may have argued, as it has previously argued, that no U.S. court has jurisdiction to order relief," in reference to the Abrego-Garcia wrongful deportation matter. The Supreme Court further stated, "At 12:52 a.m. Eastern Time, we ordered the government, in light of all these circumstances, not to remove any member of the putative class of detainees in order to preserve our jurisdiction to consider the application." The Supreme Court cited its prior ruling in Mullane v. Central Bank and Trust. Quote, "Due process requires notice that is reasonably calculated under all the circumstances to apprise interested parties and that affords a reasonable time to make an appearance." Accordingly, in JGG, this court explained, with all 9 justices agreeing, that Alien Enemies Act detainees must receive notice that they are subject to removal under the Act within a reasonable time and in such a manner as will allow them to actually seek habeas relief before removal. In order to actually seek habeas relief, a detainee must have sufficient time and information to reasonably be able to contact counsel, file a petition, and pursue appropriate relief. The detainee's interests at stake are accordingly particularly weighty. Under these circumstances, notice roughly 24 hours before removal, devoid of information about how to exercise due process rights to contest that removal, surely does not pass muster. In order to prevent misinformation, I want to make it clear. The Supreme Court's order does not release the detainees from custody, and it does not prevent the Trump administration from deporting these individuals under other more appropriate authorities and through proper lawful procedures. Keep following Executive Coup for further updates on this matter and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. Thank you.